Back to order. We will move on to agenda item number 7, which is discuss and take action on proposed orders of amendment to existing Tico rules. Mr. Beecham.
Thank you, Mr. Chair. Commissioners, if you'll look in your backup material, we'll go through these individually, and as we go through these 4, 5, 12, 13 proposed rules here, I'll be calling on some of the directors to give us some guidance and direction as for why we're doing it and give us the rationale. Some of these give you a general overview as we go into this beforehand. The proposed rules you have before you today are some are in response to statutory changes, some are in response to suggestions from the field, and some are addressing some things that we needed to normal clarification that occurs when we look at these things roughly every 2 years in response to the legislative session. So that being said, we'll take a look at proposed change number 1 to 11.1, change the definition sections, subsection 1, 2, and 3. You'll see in here the proposed new language or its successors. You'll see that through the 1, 2, 3. That is because the name of these entities do change from time to time, and instead of having a definite, concrete, only reference to those entities in these rules, we would like some flexibility or its successors for these entities, so when they do change names, we're not having to reopen the books every 6, 9 or months or 12 months, whatever the case is. So for your consideration, proposed rule change to 211.1 definitions.
We're going to do these one at a time.
I think it would probably be easier.
Okay. Motion second and then discussion.
Make a motion to approve rule number 1.
Seconded.
Have a motion and a second. Now for discussion. All those in favor say aye.
Aye.
Opposed, same sign. Amendment number 1 passes. Proposed amendment.
This is for posting. Just
This is proposed. Mr. Beecham.
Proposed amendment number 2 is a change to 217.1 minimum standards for enrollment and initial licensure. I'm going to give you the overview of the changes to this. We're going to take it in a couple sections. I'll probably have Director Merchant cover subsection A and subsection B, the changes there, up to when we get into the background investigation, because there have been some changes by staff that are not in your materials. And then I'll hand it over to Director Grigsby as we get later through this rule. However, let's first address 217.1A. You'll see that the material, there's been some deletions in this subsection that have been moved, or what that is meant to do is there's been some confusion, and I'll let Kenny get into that a little bit more here, but subsection A and B, we had some clarification we needed for the enrollment purposes of basic peace officer, et cetera. Kenny, if you have anything you want to add to this subsection A and B change, feel free to.
Yes, sir. Thank you. Commissioners, this is not a substantive change. It doesn't change policy, procedure, or interpretation, or any of the way we do business. This is strictly a change to make it easier to understand what the requirements are for enrollment and initial licensure. There is a tendency, and I have seen this through classes that I've taught, emails received, numerous phone calls received from folks who are not really familiar with our rules to interpret subsection A as the requirements for enrollment in an academy and subsection B as the requirements for licensure, which is not the intent. So it's easy for someone who may not have a lot of knowledge about our rules to just say, oh, I just have to have a high school diploma, equivalency, or a discharge from the armed forces to go into a BPOC, a basic peace officer course. So what we're proposing is to move that language down into the educational section of licensure to make it clear that all of the requirements, the age requirements, the psychological requirements, the educational requirements are the same for enrollment and licensure, with one exception, that being under the educational section that says if you have an honorable discharge from the military, after 2 years of service, you may have that in lieu of a high school diploma for enrollment purposes only and for peace officers only. So once again, no substantive changes, just an effort to clarify for folks who may not be quite as familiar with our rules as the folks who've used them for years.
So,
Go ahead.
Director Merchant, help me understand the term acceptable to the commission under A. What are we trying to?
We have standards for the documentation that's acceptable. For example, just for citizenship, the acceptable documentation is a birth certificate, naturalization papers, or your passport, visa, excuse me. Those are the acceptable documents. Some agencies may on occasion, and in the past what we've seen quite a bit of, is a driver's license and social security is what they accept for proof of citizenship, when we all know that basically anybody can get a driver's license and a social security card. So that's an effort to say, yes, you must meet these eligibility requirements, but the documentation used to show that eligibility must be something that's acceptable to us and just not whatever you choose as a document to show citizenship or high school diploma or whatever other requirement that there is.
So with that, is that documented somewhere in procedure? Or are we moving that somewhere else?
Yeah, there's in the classes we teach, but also in, for example, bulletins and a packet, an information packet that we give out to all agencies when we do audits. There's a specific listing of what those acceptable documents are for those eligibility standards.
I just want to make sure we're all on the same page as far as when we say acceptable to the commission, that everybody is clear on what that is, and it's not on whoever happens to show up at that time to do audits or whatever happens, that there is a clear, as an agency administrator or a training coordinator, whoever's responsible for doing that can say, hey, this is a document, this is where they're at, and this is exactly what I need to be in compliance with
Is
that.
it in a rule?
The specific documentation?
Is it in a rule?
No, it's not.
There are hiring documents that they have to fill out that specifically outline each of those those items as well. But they're not spelled out exactly in rule.
So it should be fairly easy to drop that laundry list of items into here.
We certainly could.
No.
Do you foresee any apprehension or maybe cause confusion or a reason not to have it clear?
Oh, no.
I mean, I'm just looking for discussion as we go through this.
It adds more language to the rules, obviously, but I don't think, it's pretty universal and pretty standard when we do audits, when we're doing our instructions, what's acceptable, and I think most of the agencies are aware of that too. We just wanted to add that to rule to make sure that everybody understood it's our decision as to what's acceptable and not their decision as to what might represent a legal document or what might be a court disposition on a case conviction or something like that.
I think it's a good point. I mean, why leave it open to interpretation to then end up coming to us over something? Let's just put the laundry list in there.
We can make that happen.
Okay, motion on amendment number 2.
We've got let's we've got a little bit more discussion, Sheriff, on that was just the first part of it, and then
I guess I was in a bigger hurry than you.
A.
that was just A and B.
Okay.
Well, did you already go to B?
No, that's where we were at right there.
Go to B.
Let's go to B. Kenny, do you want to take B as well? The commission shall issue a license to an applicant who meets the following standards.
I'm sorry, yeah. Section B is just a continuation of what we eliminated in Section A, moving those educational standards down to the underlined section where it says for enrollment purposes. That's the same language that's just moved down to the educational section of licensing. Once again, not a substantive change, just moving it into where the other educational requirements are rather than keeping it separate.
So could, a question on C, on the new C, subsection C. It says, for enrollment purposes in the Basic Peace Officer Academy only, has an honorable discharge from the Armed Forces of the United States after at least 24 months of active duty service. And so I guess, just for clarification, if I have less than 24 and I get dishonorable,
Then you don't bypass the educational requirement.
okay,
All that is a, C is simply, with that or that's above it, is simply saying you have to have a high school diploma or a GED, or if you have 24 months of active service with an honorable, it will, it can be accepted in lieu of a high school diploma.
okay, very good. I
And
understand.
Commissioners, that's actually a statutory requirement.
Yeah,
That's why that
that's
language is in there,
statutory.
yes.
Thank you.
I actually have an addition to make on something that isn't underlined. It's at the very beginning of 217.1B1. If we could add minimum age requirement, then it'll read and make more sense. Because the way it reads at the moment, it sounds like you only qualify if you're 21 years old. So if you're 22, you're too old.
So,
You know what I
understood, understood. Under B1, it reads, "The commission shall issue a license to an applicant who meets the following standards." The new, it will now insert the word minimum under B1 in front of the words age requirement.
Yeah, I see your point.
Okay. If, Mr. Chair, if I can move forward, if there's no further discussion, we can move forward to subsection 10. This is the personal history and background investigation section. If you'll recall, back in June, in the definitions related to personal history statements and background investigations, this is the background investigation as it relates to a employing or appointing agency. Before we get into a discussion, however, I want you to make note of a staff change to this particular section. If you'll look at 10A and go down to 10B, this is the change staff proposes. In addition to subparagraph A of this paragraph, a law enforcement agency or law enforcement agency academy shall require completion of, now this is the change now, as it is in your packet, the rest of that line from the word "the" to "needed" is deleted, and instead propose where it reads, require completion of a personal history statement that meets or exceeds the commission-approved personal history statement. I say again, require completion of a personal history statement that meets or exceeds the commission-approved personal history statement is how 10B Romanet I should now read.
Thank you for that.
Are there any questions about those proposed changes to 10A and 10B?
Mr. Beecham.
Yes, sir.
On Roman numeral small 2 and 3, so when we talk about contact all employers for at least the last 10 years, if applicable, obviously the if applicable would be if they don't have 10 years of employment, but if someone, are we painting ourselves in a corner if we try to call them and they just don't return calls or don't, whatever, by not saying attempt to contact? Or something in there in that?
I believe that's understood. I've spent years doing background investigations, and I think that's just part of, you do your best, do due diligence to contact those if you're unable. The business may not even be in business anymore, and you can't contact somebody. We recognize that. We're not going to hold them accountable on those if they've made a good faith effort to try to get in touch with people. That's kind of an understood. I don't know. We could try to word that in a way that would soften that, but I believe that it is pretty clearly understood that we're going to understand that they're going to do everything they can to contact, and if they can't, they can't.
So that's really, I guess my concern is that's good while we're all here and you're the executive director and
understand.
everybody's in place, but when we're not here no more and the next generation is here looking at this, how is it going to be interpreted with that? And if the intent of the commissioners and the staff here is that's the way we would like it to see, should we address it since we're here? And I guess that's my question to my other commissioners that have some experience in
Commissioner
this.
Hester, I share the same concerns. It's very black and white. It says to contact all employers, and really doesn't leave room for interpretation, in my opinion.
I think the if applicable language satisfies that doubt there. I mean, I think that if applicable language covers the scenario that you're talking about, and I think you would definitely assume that a good faith, I mean, that's what you would look at as a standard, is good faith effort. I feel like, unfortunately, if we try to soften the language, that just opens up the door to, well, I tried making a phone call at 11 o'clock at night on a Sunday and no one answered. So I did my duty. So that's my concern.
I would
if we
I would
soften
love
the
to-
language.
I would love to say that I would think that would never happen, but we've seen that kind of thing happen.
And we've actually had,
The next one, number 4, talking about contact the chief administrator, we've tried to tighten that down because we did say former agencies at which they worked, and we've had numerous, untold number of instances where what we ended up finding out was they called and talked to the receptionist at the front.
Right.
And then, yes, he worked here, and they felt like they satisfied it.
Right.
And so trying to strike a balance between, look, you need to do this, and yet make it doable and understand there are going to be exceptions and stuff is challenging. I'm very open. We're very open to other language if you feel like there's more
Well,
that fits.
I mean, I see the point that Commissioner Burris is talking about, but it's also the reason why we're voting to post it on the register
comment.
for comment.
Correction.
That if there is the issue with that's where it comes up, so.
Correct. Who knows, and that's what I was going to, thank you, Commissioner Hester, this is the first reading of these particular rules. Oftentimes, or at least sometimes through public comment, a lot of these issues are oftentimes issues that we don't even think of while we're either drafting them or discussing and considering them here, come up during the public comment section, and the duty experts often come up with a solution to those concerns that we may have. So
Yeah, for our duty experts that are in the audience or listening online, when that gets posted, make sure you look at it and send your feedback in.
I do want to point out Commissioner Atkins added that, suggested that language with the chief administrator's designee, or the chief administrator, and that was really well done.
Yes. In doing, as a training coordinator, when we do the academies, definitely need to contact, I'm comfortable with the language, contact all previous enrolling entities, because there are subjects that don't complete an academy, and they never go to work, but they've applied for an academy and haven't made it, and we aren't aware of that. They're not forthcoming to say why we got out of this academy. So I agree with that language, and yes, on contacting the chief administrator or his designee, because you can just have somebody answer the phone and you say, well, I'm checking on this, and they'll say, oh, well, he's good. Well, sometimes that doesn't work.
We had a lot of discussion on that particular wording about just chief administrator, but then that's not realistic, because if you're talking about the Dallas Police Department or the San Antonio or Austin Police or Houston Police Department or Harris County Sheriff's Office, you're not going to be able to talk to the chief. It's just not going to happen, or the sheriff themselves. So that's why we put the designee in there as well. But we are trying to tighten that down to where it's somebody that can actually give information on the employment.
Yes, I have seen that in my history. It's someone just, you call and you can't get a hold of the chief or the designee, and they're saying, oh, yeah, he's a good guy, and you find out ultimately it's not, so.
I don't have any other questions, sir.
if no further questions on that particular passage, we'll move on to the next one, and here we have a,
I would like to
Excuse me,
vote, I'd like to have a motion and a second on it.
Can I have one more thing, Mr. Beecham?
Is that what you're talking about?
And I guess I'm just
No, I'm
not
sorry.
reading it right. It says on 10, it says, has been subjected to an investigation completed by blah, blah, blah. We've marked out that part of a background, but then the second sentence, a background investigation shall include. I just need clarification why we marked out a background investigation in the first part, but then put it back in that second sentence there. If you see what I'm saying on number 10.
I do.
It says to do an investigation, but then it says a background investigation. Just clarification, they may say, well, this isn't in background, so I don't have to do that. Do we need to add that back in, or just leave it the way it's written?
And I think, and I'm going to refer back to the best of my memory, can recall the exact wording of the definition that we talked about, that we finalized in June. I think what we wanted to do was have the broad term investigation at the beginning of the sentence and the background investigation term that
Okay.
makes it specific in the components of it. And what we can do, though, to be certain of that, is during this period when we have public comment, we'll go back and we'll look at that rule to make sure if that's something that we can, because that's of a change that would be no problem to make if we put it up for final adoption. And I'll make a note of that and to see exactly why we did that.
Okay,
Thank
thank
you
you.
for bringing that up.
Go ahead.
Commissioners, we have another change that was brought to the attention of executive staff within the last week. It's not in your notebook. It's under subsection B, but it's not in your notebook. This would be subsection B13. This relates to requirements or disqualifiers for a person who had received a dishonorable or other discharge based on misconduct which barred future military service. I will walk through kind of the proposed language to the current rule, and then I'll turn it over to the executive director as to to kind of give the rundown of the discussions that we've had and the kind of cases that we've been seeing. What executive staff is proposing on 13, again, as it reads now, has never received a dishonorable or other discharge based on misconduct which bars future military service. What we're proposing is to simplify and reduce the categories which would prohibit a person from becoming licensed or appointed to simply and only dishonorable discharges. As a result, the language would read, has never received a dishonorable discharge. So this would expand the categories of discharges which a person could have and become licensed or employed. And again, this is a minimum licensing standard, not an employing standard or anything else. Excuse me. Kim, do you have anything to add to?
Yes. We've run into some instances in dealing with DD-214s and with military discharges. They've become more and more and more complex. And when we originally, years ago, was you had to have an honorable. We got off of that because there was such a variety of discharges that really didn't have significant misconduct on them, but they weren't honorable, so we backed off of that. They showed me a history they've shown of the changes in there. This has gone back and forth now for several years. We landed where we currently have it, where either they have a dishonorable discharge or other than honorable that has bad conduct and they're not eligible for re-enrollment. And it talks about court martials, and at face value that works. You may not want somebody that has been charged with something in the military and court-martialed, and they didn't get a dishonorable, but they didn't get an honorable, and it fell into that bad conduct. What we have seen are more and more instances of those being used for a broader spectrum of situations by the military. Silent insubordination is one that we saw, where a person got a bad conduct, not eligible for re-enlistment, over silent insubordination, which is not necessarily criminal behavior or something that somebody that wasn't in the military, it wouldn't be a prohibition for them to be able to get their license. So we struggle, and we've got people that do this all the time, and we struggle looking at the DD-214s and all the different discharges that are coming out now, and using that criteria, we struggle to figure out whether this person's actually eligible to come to work and be licensed or not. If we're struggling, we can imagine what smaller agencies that don't have the resources we do, and the background, that people that have that background that can understand that and are constantly looking at it, that the position it places agencies in trying to determine whether this person's eligible or not. And while we may be, by backing off of that a little bit and saying, okay, the only one that is going to be a disqualifier is a dishonorable, that may open the door for potential licensing of some people that may be a little questionable. Our hope is that that's caught in the background investigation. If they're doing a proper background investigation, they'll discover that. But I'd rather face that fact than to have people that would be good officers, would be good licensees, that are not getting that opportunity because of a misunderstanding on the way the DD-214 is done. And I'd rather deal with making sure we try to catch a few bad ones than excluding people that don't need to be excluded, that should have the opportunity to be licensed. And so our recommendation is to back off of the DD-214 restrictions to where it simply says, if you have a dishonorable, then you're not eligible. Other than that, then it's going to be a case-by-case basis that the agency needs to look at in their background on whether this person is someone they want to hire or not.
Commissioner Taylor, I have a question for you on this. When it comes to the reasons other than dishonorable discharge in the military, and you said that there's been a lot of changes over the years. Are you aware of what all the other conditions could apply to other types of discharge? I'm older, so my discharge goes back quite a ways. But we used to have one called administrative under other than honorable conditions. Now, that included people who admitted to the military that they had extensive drug use while serving in the military. And they made that statement in order to obtain an administrative discharge rather than undesirable or dishonorable. Mm-hmm. That gets into a lot of weeds.
It does.
Have you had a chance to get into the weeds?
We've been in the weeds, yes, sir, on some, and it's what prompted moving in this direction. We've had cases, and while I by no means condone this at all, we had a case of a bad conduct, ineligible for reenlistment because they had an affair. Okay, now I by no means condone that, but by the same token, is that a criminal action or an action that says a person should not be able to be licensed? Well, that should be a department decision. You know what I'm saying? I don't believe that's a minimum standard decision. And we couldn't find a way to rectify getting in the weeds and all these different deals and still exclude people that really had no real business being excluded. So that's why we took this direction.
Having gone through some excellent training with your organization yesterday, this was one of the topics they covered. And the point was made that the agencies are the gatekeepers.
Yes.
To make sure that this process of acquiring certification is a clean, consistent process. So my question on this issue is, will that agency, that small agency that doesn't have all the resources, be able to make a determination given what is going to be available to them on this topic?
Probably not, but they're not going to be able to do it either way. I know what you're saying, and that's a concern. I mean, it's a concern. We just felt like this was for a minimum standard, this was the best way to address that gave full opportunity for people that should have the opportunity to be licensed to do so and not get excluded otherwise. Now, it's a problem for smaller agencies that don't have the resources either way. But we felt like this was a more fair approach to it and truly excluded people that were intended by the military with a dishonorable discharge to be excluded.
Mr. Victors, will this tie your hands as far as, okay, say I accept one in the academy that does have the court martial, and does that tie your hands to where if you do come in and audit or whatever, and you find out that the court-martial was criminal, you can act on that, but if it's something else, it's just up to the individual agency?
It's
Correct.
going to be the agency as the gatekeeper,
Okay.
is what it is on that. I don't believe, if they comes in and it was a drug issue in the military, maybe they got charged with some sort of drug possession or court-martialed, or then it is possible that they could find their way in, and yes, it would tie our hands because they did meet minimum standards.
Okay.
Once again, we've weighed which is is that more likely, or is excluding people more likely, and we've gone with the minimum standard of, we don't want to, it's not our job, in my opinion, to try to keep people from being a law enforcement officer if they want to. Some people don't need to be a law enforcement officer, but I don't see it's our job to make that as difficult as possible for someone that it's not as clear cut as others, but it's not significant enough to keep them out. That would be I think that would be a department decision.
Commissioner, in the instance that you bring up, if there's a criminal conviction in the military, it will still show on their CCH. Okay. So it won't be dependent on what the DD-214 says. They'll still be able to find that out through the criminal history background that they do on somebody.
Okay. And I know from my aspect, when I get these, it's really hard. I totally agree to figure out what they've been court-martialed for and whether it's criminal, whether it's not, et cetera. So I definitely agree with this.
And just as a historical note, Director Antu brought to me a sheet, is 2 or 3 pages long, of changes that we as a commission have made over the course of the years to try to always hit this moving target, because the military is they're always in flux as to how they characterize certain behaviors, and it changes from unit to unit even, and we've any weeds that we've gotten to as a commission over the years, we've kind of done it to ourselves, because we've probably assumed some expertise on our part that to some extent we can get information on these cases, and that's the problem with sometimes, is it's written right now, there's just not enough information to go behind these discharges, and we are often confronted with a person being allowed to pursue the law enforcement career or not based on a very limited set of information and documentation that we have before us because of the way we're addressing this now. Whereas a dishonorable discharge is an objective, clean standard and category which doesn't require the same depth or access to information that we're dealing with now.
And in a perfect world, where a good background is being done on everybody, I would hope that if it's a person that has no business having a license, and this was just one piece of it, that would manifest itself in multiple fronts across their background. You would see it in multiple places, and we always did when we were doing our backgrounds. So it's a little bit of a leap of faith, but it's trying to be as fair about this process and still retain some sort of standards on this.
I do have one other thing to add. From my experience, it goes way back. But the term used for background investigations, at least on the federal level, was other than honorable. Mm-hmm. Did you ever use that term in your background screening?
In the backgrounds
in your
that we've done?
Process, yeah, instead of saying undesirable or dishonorable or administrative discharge, being an unqualified person, they would use the term, did you ever receive a discharge other than honorable?
We see those all the time, yes, sir. Other than honorable, we see that very frequently.
I just wondered if that would be a standard that would be helpful here to anybody that had other than honorable, and they list, yes, I did have other than honorable, then they'd have to explain what it was and show on their DD-214. That could raise a flag that would allow the agency then to look into it a little bit further. It seemed to work. I just wondered if that's a viable.
I think that's what they're trying to address, unless you have, so if you see an other than honorable, unless you have the magic book of the separation code and the reentry code between each of the branches to know exactly what was the reason that they left and how can they come back. And if I hear staff correctly, I think that's what they're trying to address, to say, hey, that's a local decision that the local agency can do during the background. Look at that other than honorable, look at the codes, do that background investigation. But the hard and fast rule that the commission will say no to is dishonorable. And then other than that, the agencies can leave up to them how they want it. Some agencies may keep exactly the way the rule is currently to say, hey, we'll look at those at a case by case. Some agencies are going to accept exactly what we're writing, and unless it's a dishonorable, they're going to.
I think that covers it for
Into
me.
the
The new issue for me was the code. That didn't used to be on DD 214.
Yeah, and
Okay.
in my experience on looking at the codes, even the book I used to have was dated, and the military doesn't actually publish the codes.
Right.
So it's very hard sometimes to get that information, and I think that's where the direction is. Do the background,
Good.
and hopefully we can come to it. I see what they're trying to get to.
Any further questions on the proposed language to B13? Commissioners, we'll look next at subsection G. This is the last proposed change to proposed amendment number 2. You'll see this was in response to HB 4468. Gretchen, if you could briefly give us a rundown on what this change does.
Certainly. So any sheriffs in the room or listening online are quite familiar that there were many discussions on changes to temporary jailer licenses, and the language that you see before you is reflective of what ultimately passed, and that is that a temporary jailer must be enrolled in a basic licensing course within 90 days of that temporary jailer appointment. And that means just that. That does not mean that they have to have completed the course. It does not set out any time frame beyond that 90 days within which they need to complete the course, other than the fact that that temporary jailer license is good for 1 year and 1 year only, and they cannot get a new temporary jailer appointment at any time beyond the expiration of that 1 year.
Okay, are we ready to move forward then?
That's
on
it.
Proposed amendment 2.
I make a motion to approve proposed amendment 2 with the addition by Mr. Beecham.
I second it.
Have a motion and a second. Is there further discussion? I want to say this to the commissioners. Thank you for reading these so very closely and helping to chief administrators across this state to have a document they can be clear about. All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Beach.
Commissioners, let's take proposed Rule 3 and 4 together, law enforcement agency audits. This simply, the result of the audit, changing will to may be forwarded to the chief administrator and governing body. This allows the field agents to have the discretion to forward a report or result of the audit or not, depending on the situation. Sometimes there may be an enforcement act or something forthcoming, so this would give them that leeway in the rules. 21717, reporting appointment and separation of licensee. This relates to F5 appeals, and what this does is this conforms and refers all procedural questions regarding the F5s. It just refers back to 1701-452 to ensure there's consistency between the rules and the statute and the form. Proposed Rules 3 and 4 for your consideration.
Motion and a second, then discussion.
I make a motion to accept proposed rule amendment number 3 as written.
And 4.
And 4, sorry.
Seconded.
Second.
Have a motion and a second. Further, now it's time for discussion. All those in favor say aye. Oops, oops.
Okay. We took out the number of days. We don't have anything there. So,
That in there?
well, immediate, I mean, right now it just says, when a person licensed by the commission separates from an agency, the agency shall 1 and 2. But there's no time frame, so it
about we put-
kind of just leaves it open that they could say, well, I had the intent of doing it. 3 years later.
Sure, we can certainly put that back in. What we'll do is put within 7 business days to conform with 1701-452, and we will leave the rest of that, what's been marked out, because we want to make sure that
Yeah.
there's no confusion regarding local appeals. If that's a change we want to make, Commissioners, on proposed amendment number 4, when a person licensed by the commission separates from an agency, it will now say the agency shall, within 7 business days, colon, and the remainder of that strikeout remains the same. Is that correct?
Yes,
Okay.
correct, thank you.
So does that match 452, 1701, 452?
Yes, it does.
Okay.
Have a motion and a second.
Do we have?
Huh?
Oh.
Is there any other discussion? All those in favor say aye.
Aye.
Opposed, same sign. The proposed amendment 3 and 4 pass. Proposed amendment number 5.
Commissioners, this relates to proposed changes to 218.3, legislative required continuing education for licensees. I'll turn this over to Director Grigsby.
The changes that you'll see under 218.3 are all the result of legislation. Under number 2, House Bill 1415 requires elected constables to go through the civil process training, which is what we had already discussed earlier in this meeting, that will be done through the Justice Courts Training Center. For school-based law enforcement officers, that's your ISDPD officers or your school resource officers. There were 2 changes in 2 bills made to that. The first, of course, under Senate Bill 11, being that now applies to districts of all sizes, not just those of an enrollment of 30,000 students or more. And the second change being under House Bill 2195, which is that this certification now includes a component of active shooter training, which we have been working on developing in coordination with ALERT and a number of other committee members. The final change is that these officers have 180 days within their assignment instead of 120 days to complete those requirements. Next, officers carrying epinephrine auto-injectors. That is for an agency that decides to obtain epinephrine auto-injectors, EpiPens, and issue them to their officers to carry so that they can be an immediate responder. As you all know, anaphylactic shock can take effect very quickly. They need to get training on how to use those before they carry them in their vehicle. That is an optional thing for those agencies to do, and we are working with the Department of State Health Services on finalizing that. Next, jailers carrying a firearm. They need to, if a jailer is going to carry a weapon, they need to go through the training and certification for that. Simple as that. And then under 11, university peace officers, and Commissioner Lebeau, you and I have had a few discussions about what will constitute this trauma-informed investigation training. We will have on our website a few of the classes that exist that will apply to that standard. It does not charge Tico with developing a specific training for that. There are plenty of other courses already in existence that are broadly applicable to that requirement. And so we will make that available, those recommendations available. This is also not a requirement that we are going to be running compliance on. That is just a requirement for the universities to make sure that their officers are getting that training. Bottom of page 5, you will see the human trafficking requirement. That was under House Bill 292 that we requested, that would incorporate human trafficking training that was previously assigned to be taken after an officer gets licensed, can now be incorporated into the basic peace officer course, or within 2 years after being licensed, which of course will be taken care of through attrition of those who are getting it in the basic peace officer course.
Director Grigsby, on subsection 10, it says 10, on our copy, it says 10, and it says title. Was it supposed to have something else there, or am I missing something without the full text?
That is an excellent question, and something that I believe we'll be resolving before it goes to the Texas Register.
Was it meant to put the title, say, jailer firearms?
It's going to be the course title, we just didn't have it at that time.
Okay.
So on D2B, I'm proposing removing the language for constables. It's already under 2, which lists constables. It's redundant. We take that out. That's the first line of D2B, each 48-month cycle, at least 40 hours of continuing education as provided.
And remove the word "for constables"
Correct.
before the current strikeout each 48-month cycle.
Correct.
Okay. Done.
Now on 11, it looks strange to me to have colon and then another colon in the same section. It's weird.
So let's see if we can, do you have any proposal that you would add to that? Or we can certainly do that before we send it to the register, or after, we can bring that back to you in final adoption in some format, which wouldn't be as awkward as that.
Just something that doesn't look
Understood.
strange like that.
A dash or a forward slash or?
Anything.
Commissioner Burris, if we could back up to the constables training there. The reason that's listed as continuing education for constables is because Bill Blackwood teaches multiple different versions of continuing education for chiefs, for constables. So if we took the constables out there, would that imply that they could take the continuing education for chiefs and meet the requirement?
You're saying Bill Blackwood Law Enforcement Management Institute, they need the
It has
specific.
2 different types of continuing education for chiefs of police and for constables.
Right.
So if we took the constables out of the particular class they had to take, would that not open it up for them to take the chief's continuing education
Okay.
Instead.
instead?
Each 48-month cycle, at least 40 hours.
Good point.
Makes sense then.
Yeah.
Yeah.
So we're putting 4 constables back in now.
We are. And we've already selected the institution of higher education. That's what Mr.
Yes.
Vickers spoke about earlier in the report. And do we want selected, approved? Is there a difference? You've already selected them.
We've selected it.
You've always select them, but
Approved?
I don't know if there's a
In other words,
substantial or
list it,
material difference
actually list
between. Do I?
Are you saying actually list who we selected?
No, I just don't know if there's a material difference in selected or approved consistency of language, but that's fine. We'll look at it again.
I'll make a note of that here, something we'll take back and take a look at. How's that sound?
It might be better just to clear, since it does say as provided by Bill Blackwood Law Enforcement Management Institute for the first part, since we have selected who will be the institution delivering other, might just list the institution, just like we did Bill Blackwood in the first one. I mean,
Well, if we list the institution, then we have to come back and change the rule every time it's a different institution. So I'd
Okay.
rather not hamstring us to that, but.
The reason why Bill Blackwood is listed is because that's actually what's listed in
That's
statute.
statutory. That's
So
statutory.
That's why that name is actually there.
That's all I have.
Make a motion to approve proposed rule number 5 as discussed.
A second.
I have a motion and a second. Is there any further clarification or discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Proposed rule number 6.
Commissioners, proposed rule number 6 makes changes to 218.9, continuing firearms proficiency requirements. Gretchen, do you want to take this one too, please?
Absolutely. So 218.9 is another change that is the result of legislation. Both House Bills 1552 and 3503 made identical changes. Any jailer who's carrying a weapon needs to get the firearm certification.
Make a motion to approve rule number 6 as presented.
I second.
Have a motion and a second. Is there any clarification or discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Amendment number 7.
Commissioners, next is proposed amendment number 7. This deals with Rule 219.2, reciprocity for out-of-state peace officers, federal criminal investigators, and military police. Director Merchant.
Commissioners, under our current rule, veteran officers from out-of-state military and federal agencies are actually penalized in the process of becoming a Texas peace officer, in that if they have been separated or retired for more than 2 years, they basically have to go through a full peace officer academy in order to get a license. At the same time, we allow an officer with 2 years of experience from, say, Oklahoma, to come straight across and get a lateral entry license in the state of Texas, just based on the fact that he hasn't been separated for 2 years. So for the last year, by waiver through the executive director, we have already had this working policy in place where we have eliminated that recency requirement. In other words, the 2 continuous years within the last 4 years, which just basically says you have to have worked within the last 2 years, is what it boils down to. We've been very successful in that process. We have not hit any glitches. It's allowing those, and I could name a number of veteran officers from out of state, and in particular from agencies like the FBI and DEA, to come in and get a Texas license without having to go through the full academy, which they probably would not have done otherwise. So this is an effort to make it more equal for those veteran officers coming in from out of state. And once this is approved, this will allow us to apply a system like we do with our reactivation, which bases your training to come in as a lateral or to regain your license according to your years of service and how long it's been since you served. So once again, for officers that have over 10 years of service, their training requirements would be less. Officers whose separation has been less would require less retraining to get the license. Our reactivation and our out-of-state licensing process will basically mirror each other as far as the requirements for those officers.
Make a motion to approve proposed amendment number 7.
Seconded.
Have a motion and a second. Is there any other discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Proposed amendment number 8.
Commissioners, proposed amendment number 8 is changes to the reactivation of a license rule 21911. Kenny, if you could take this one too, please.
Yes, several years ago, before we had some legislation that changed the reactivation process for peace officers only, our rule addressed all licensees as far as reactivation. When the legislation occurred, we rewrote the reactivation rule, but left off the jailers and the telecommunicators, so it really only applied to peace officers. This was an effort to put the rule back in place that applies to jailers and telecommunicators. It's the same process that we have been using for years. So there's no substantive changes, procedural or policy changes. It's just now reflected in rule, whereas it was not before.
Okay, motion.
I make a motion to approve proposed amendment number 8.
Second.
Have a motion and a second. Are any questions or discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Proposed amendment number 9.
Commissioners, if there's no objection, since these are all proposed amendments, 9, 10, and 11 are all in response to legislative actions, if we could take those together, and Director Grigsby may have some notes she wants to give you on each one of these.
I think 10 and 11 we probably already covered, if not ad nauseum, but 9 I will address very quickly, and that would be similar to a bill that passed last session, which gives some additional training hours for individuals who complete the law enforcement endorsement as part of their high school credits. We realized when it was brought up by the legislator who passed this bill that there was not some sort of equivalent for those who had military experience. And so what we are looking at for this is giving some credit for military experience and putting into the rule a process that's been in place for a long time as far as college credit, giving some additional hours for those types of service as well.
Mr. Chairman, so on number 9A1, when we talk about accredited colleges, was there a difference in House Bill 971 and then what we do as a commission on the different accreditation agencies?
House Bill 971 actually only addressed the military service part, but when we started discussing it, we realized that there was not anything in writing that addresses the current process for issuing hours for college
So
credit.
this doesn't
we're-
cause any conflict with what our current practices are?
Correct.
Very good, thank you.
Number 10.
Numbers 10 and 11, I think we have already covered, so we are good to go on those.
I make a motion to approve the proposed rules 9, 10, and 11.
Second.
Have a motion and a second. Is there any questions or discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. And I believe that that completes agenda item number 7.
That's correct.
Thank you, Commissioners.
Well done.
I appreciate the close reading you guys give to this, and I hope everybody will when they're posted online. Make sure we get them right. We will move to agenda item number 8, which is discussion of and take action on proceedings for revocation, suspensions, and other disciplinary actions. And I'm going to call on the Office of Attorney General, Mr. Winter.
Good morning, Commissioners. Raymond Winter with the Attorney General's Office. The first disciplinary matters for your consideration are default suspension orders proposed. The 4 individuals listed here are all received convictions or community supervision for criminal offenses giving rise to the institution of disciplinary proceedings to suspend their licenses. All 4 of these individuals failed to respond to notice of the Executive Director's enforcement action, and consequently, the Executive Director now recommends entry of default orders suspending their licenses. And these individuals are Eduardo Garza III, Eugene R. Lancaster, Michael J. Matthew, and Adrian Valley. And again, the recommendation is entry of the proposed default orders suspending their licenses for 10 years.
Thank you. Commissioner Hester.
I move that the Commission accept and adopt the recommendations of the Executive Director to enter a default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, and as required under the provisions of the Texas Occupations Code, Chapter 1701, Section 501, to suspend the license of Eduardo Garza, Eugene Lancaster, Michael Matthew, and Adrian Valley.
Seconded.
Have a motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the next individual before you has entered into negotiations with the Executive Director and agreed to the suspension of his license for a period of 10 years, and that is Titravius D. Gray. And the Executive Director recommends that the Commission accept the agreed order suspending Mr. Gray's telecommunicator license for a period of 10 years.
Commissioner Hester.
I move that the Commission accept and adopt the recommendations of the Executive Director to enter a final agreed suspension waiver for Titravius D. Gray.
Second.
Motion and a second. Is there any discussion or questions? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the final 3 individuals before you for your consideration all engaged in criminal misconduct giving rise to proceedings brought by the Executive Director to revoke their peace officer and/or jailer licenses. Again, these individuals failed to respond after receiving notice of the Executive Director's enforcement action and now have subjected themselves to default action. The Executive Director recommends entry of default revocation orders for Guy E. Bender, Samuel F. Harris IV, and Hugo L. Juarez.
Commissioner Hester.
I move that the Commission accept and adopt the recommendations of the Executive Director to enter a default final order as authorized under the provisions of 37 Texas Administrative Code, Section 223.3, and as required under the provisions of Chapter 1701, Section 501, to revoke the licenses of Guy Bender, Samuel Harris, and Hugo Juarez.
Seconded.
Have a motion and a second. Is there any discussion? All those in favor say aye.
Aye.
Opposed, same sign. Motion carries. Mr. Winter.
Commissioners, the remaining items on your agenda require no action. These are for your information only. There's one individual who committed an offense, a felony offense, giving rise to a summary statutory revocation. That's Mr. Hernandez. And then you have a number of individuals listed under the heading of permanent surrenders. We heard a little bit about that earlier today. These individuals have all submitted paperwork to the executive director permanently surrendering their peace officer and/or jailer licenses as applicable, and these have all been accepted by Chief Vickers. The final individuals listed on your agenda received reprimands for administrative violations such as failure to report offenses. And again, this is all informational only.
Thank you. Thank you very much. We'll move to agenda item number 9, which is receive public comment on any topic without discussion. I don't have anyone signed up to speak, but if anyone wishes to address the commission just for public, during the public comment period, please come to the podium and introduce yourself. Okay, I thought there was going to be somebody here, but they're not, evidently. Ladies and gentlemen, we're going to go into executive session, and when we return, there will be no action taken. We will just adjourn at that time until December 5th, 2019. Thank you for your attendance today. I'm going to ask everybody except the commissioners and the executive director and Mr. Beecham to please leave the room. Thank you.